Duties in regard to the inventory of her husband. It is provided by the 17 IRS 742 3 RS 5th edition 33 that she may tarry in the chief house of her husband 40 days after his death, whether her dower be sooner assigned or not, without being liable to any rent for the same. And in the meantime, she shall have her reasonable sentences of the estate of her husband. This citizens sustenance is to be provided out of the personal property of the husband and through the executor or administrator, if one be appointed prior to the expiration of 40 days, and is to be given according to the circumstances and station in life of family to the widow and necessarily to the children dependent on her, for it is impossible to separate the widow from her infant children. But C. Johnson v. Corbett, 11 page 265. In providing this sustenance, the executor or administrator must exercise judgment and discretion in the same manner as in paying funeral expenses. Thus, if the estate be abundant to pay all debts without doubt, item of mourning clothing for the widow and family may be included in the charges for sustenance. While if the estate be involved and the question should arise as against creditors, bare necessary only could be allowed. Return of inventory, how compelled, and effect of not returning it. If inventory shall not be returned and filed in the office of the surrogate within 3 months from the issuing of letters, or within such further time, not exceeding 4 months, as the surrogate shall for reasonable cause allow, application of a party interested as legatee, next of kin, or creditor to surrogate will issue a summons to the executor or administrator requiring him, usually in from 6 to 10 days, to appear before him or her him and return of inventory according to law, or shall cause why the attachment should not issue against him. The surrogate may issue such a summons without an application. 2 RS 85, 3 RS 5th edition 172, see petition, order, etc. If after personal service of such summons, such executor or administrator shall not, by the day appointed, return such inventory on oath, or obtain further time to do so, the surrogate shall issue an attachment against him and commit him to the common jail of county, therein to remain until he shall return such inventory. See Form Appendix. If a summons cannot be served personally by reason of the executor or administrator absconding or concealing himself, or if after being committed to prison, such executor or administrator shall neglect for 30 days to make a return such inventory, the surrogate may revoke the letters before granted to such executor or administrator. See order for revocation, etc. in appendix. The cause of the proceeding may, in discretion of the surrogate, be charged against the executor or administrator personally. SL 1867, Chapter 782. And thereupon the surrogate shall grant letters of administration of the goods, chattels, effects of decease to the person entitled thereto, other than such executor or administrators. In the same manner are original letters of administration or letters testamentary. Such letters shall supersede all former letters and shall deprive the former executive administrator of all power, authority, and control over the personal estate of the deceased, and shall entitle the person appointed by such letters to take, demand, and receive the goods and effect of the deceased wherever the same may be found. The bond given by the former executive administrator may be prosecuted under direction of the surrogate by the new executor. Administrators to full extent of any injuries sustained by the estate of the deceased by the acts of omission of such executor or administrator, and the full value of all the property of the deceased received and not duly administered by such executor or administrators. The executor or administrator imprisoned in these proceedings will be discharged on delivery on oath all the property in his hands to his successors, and one or more of the executive administrators named in the letters on the neglect of the other may return an inventory, and those so neglecting shall not thereafter interfere with the administration or have any power over the personal estate of the deceased, but the executor or administrator so returning an inventory shall have the whole administration until the delinquent shall return and verify an inventory according to law. Whenever personal property not mentioned in any inventory that shall have been made afterward come into possession or knowledge of an executive administrator, he shall cause the same to be appraised in the same manner as before directed, and shall file in the new inventory within 2 months after discovery of the property. 86 3RS 5th edition 173. The making return of this inventory may be enforced in the same manner as in the case of the first one. The necessity of taking an inventory becomes obvious from the following advantages occurring to the executive administrator. The inventory fixed the prima facie value of a state and the items composing it, and parties contesting on final settlement of the accounts have the burden of proof in attempting to surcharge it as the value of items included therein or items omitted where no inventory is made. However, the burden of proof is upon the executor and administrators to show, if demanded, that the whole estate is accounted for, or if the value of an item is disputed, he must show that he accounts for its full value, and all items must be accounted for at their apparent value, or he must show that they are worthless or bad. As for instance, a book account must be accounted for as it stands, unless the executive or administrator shows that he has been unable to collect it. But if the inventory shows that certain demands are either bad or doubtful, the party contesting must show that they are good and bring it to the knowledge of the executor and administrator. The subject is treated further in chapter on final settlement and accounting, which see. Of the collection of the estate, compromising debts due the estate, and advertising for claims. All right, this is 63 to 68. Okay, we're going to start on another page.